I would like to welcome everyone to our speaker program today, part of our U.S.-Japan Short Takes speaker series. Our topic is mandatory bargaining with a minority union, the law of collective bargaining in Japan and the U.S. And our speakers are renowned experts on labor law in Japan and the U.S. respectively. Professor Hiroya Nakakubo of Hitotsubashi University in Tokyo, and Professor Alan Hyde of Rutgers Law School. I'm Bruce Aronson, Senior Advisor to the Japan Center of the U.S. Asia Law Institute and an adjunct professor at NYU School of Law. I'll be the moderator today. I would like to thank our co-sponsor for this event, the Apex Study Center at Columbia University. Before we begin, I would like to give you a brief announcement about our next program. Next week is spring break, but the following week, 2 weeks from today, we will be meeting at the same time and place. The topic will be Business and Human Rights, Japan-based NGO's perspective. Kazuko Ito, a Japanese attorney and founder of Human Rights Now and a former NYU visiting scholar, will discuss her organization's activities to promote awareness and implementation in Asia of the UN guiding principles on business and human rights. And that will include how her organization investigated and campaigned against exploitative working conditions at Uniqlo factories in China, and their current campaign against Japanese companies' business relationships with the military junta in Myanmar. I'm looking forward to returning here as moderator for that event. So today we have two speakers. Their full bios are on our website. The short version for today is first, very pleased to welcome my former colleague at the Hitotsubashi University when I was there. We were together for 5 years, Professor Hiroya Nakakubo. He is a professor of law at Hitotsubashi University Graduate School of Law in Tokyo. He's a member of Japan's Labor Policy Council and also the Central Minimum Wage Council, and a former member of the Central Labor Relations Commission, the Japanese equivalent to our LL.B in the US. Professor Nakakubo has written widely about both Japan and the US in the field of labor and employment law, in both Japanese and English. I will not cite all his publications, but I will note that I used 2 of his English articles in my class on law and society in Japan. I don't think you knew that, but so he also holds an LL.B degree from the University of Tokyo and an LL.M for Harvard Law School. Alan Hyde is a professor of law and Sidney Reitman Scholar at Rutgers Law School. He's an expert on labor, employment, immigration law, labor rights, and economics of labor mobility. He's the author of Working in Silicon Valley, 2003, and Bodies of Law, 1997. He has written about the rights, powers, and experience of U.S. employee caucuses and unions representing less than a majority. Before coming to Rutgers, he was an instructor at NYU School of Law, so we're glad to welcome him back, and the National Labor Relations Board and Federal Courts of Appeal. He's also a member of the American Law Institute and consultant to their restatement of employment law. He earned his AB from Stanford and his JD from Yale. So we are pleased to welcome both our speakers today. Lately, labor unions have returned to the news, seemingly after a somewhat prolonged absence. In the U.S., union victories in NLRB elections at Starbucks and Amazon's and other places have increased people's awareness of an interest in unionization. In Japan, worker compensation levels and labor mobility are hot topics as part of the effort to maintain and improve economic growth in an aging society. In both countries, this renewed interest in unions probably also reflects increasing concerns about economic and social inequality and working conditions in the important service sector. So it is very timely to hear from Professor Nakakubo and Professor Hyde concerning an interesting and distinguishing contrast between the two labor systems, the majority rule for union representation in the US and the lack of such a rule in Japan. We'll also hear more generally about labor law and the role of labor unions in the two countries. Our program today is 60 minutes. We will first hear some opening remarks from each of the speakers. followed by a conversation among us, and then we'll move on to Q&A, both in person and online. As a reminder for our online audience, please use the Q&A icon to send us questions. The chat function is not operating. Our executive director, Catherine Wilhelm, will be monitoring the questions from the online audience and repeat them for us. So let us begin. Gentlemen, thank you for joining us today. Professor Nakakubo, why don't you start?
Hello, everybody. I'm Hiroya Nakakubo, and I am very happy and honored to be here today with you to speak about the law of collective bargaining in Japan and the US, together with Professor Alan Hyde, a wonderful scholar and a good friend of mine. It is also fitting to speak about labor unions at this time of the year, because in Japan, annual spring labor offensive or spring wage negotiations called Shunto are taking place. Prices have risen significantly in our country too, and unions are demanding a 5% wage increase. This is the highest in 30 years. However, the reason I decided to talk about unions today is because the resurgence of labor unions has been making headlines in the United States recently. Unions' victories in LL.B elections at Starbucks and Amazon. And it's also, these victories were reported in Japan too, widely. And but people are not sure what this election means, because we don't have such elections. So people's attitude would be, why don't the union supporters simply get together and form a labor union of their own and demand collective bargaining? And so I had to write an article explaining the system of US to the Japanese people, because I have studied the US labor law for a long time and know this unique American system. But we don't have such a system, a majority rule and exclusive representation under Section 9A of the National Labor Relations Act of 1935. So I want to talk about our system and hope to compare it with the American system explained by the Professor Hyde. So first, I start with the Japanese law. So our constitution, adopted after the Second World War, guarantees the right of the workers to organize and to bargain and act collectively. This is something like Section 7 of the National Labor Relations Act. And the Labor Union Act of 1949 says, obligates the employer to bargain in good faith with a union representing its employees. And refusal to bargain is an unfair labor practice. This is imported from the United States in 1949 when this statute was adopted. And the Labor Relations Commission, which is the counterpart of the NLRB, issues a remedial order for the violation of this duty to bargain. However, there is no majority rule and exclusive representation. So a union has a right to bargain whether it is a majority union or not. And each union bargains with the employer representing its own employees, its own members. So this is a very big difference. So actually, GHQ, this means General Headquarters of the Occupational Forces, Allied Forces. And it tried to impose us this majority rule in 1949. But people were at a loss what this means. Why do you have to have an election? So it went nowhere, and we ended up having duty to bargain, but not having majority rule. So this 1949 Act was actually the second one. So 1945, we have old Labor Union Act, but that was very different from the current one. So I shouldn't spend too much time talking about this, but at that time, we could have had such a majority system imposed upon us, but in 1949, it was a little too late. And so I moved to labor unions. Whatever our legal system, Japanese unions are unique in that they are called enterprise-based unions, meaning that only the employees of one particular company, employer, belong to that union. So each company has its own enterprise-based union. And I don't like to call it company union, but they are friendly and understanding of the employer situation. And in many cases, there is only one union in the company and everyone joins it. Because the Japanese people like to do as others do. And it is very difficult for us to do a different thing. So legally speaking, you don't have to belong to this particular union, but when everybody else is doing so, you tend to join that union. But sometimes this is imposed legally by the agreement between the dominant union and the employer, what is called the union shop agreement. And the union shop agreement is quite popular among Japanese companies. So if you don't belong to this union, you are fired. That is written on the agreement. So by the use of this agreement, exclusivity is actually realized. So it's a kind of exclusive representation in Japanese style. But legally speaking, this union shop agreement is not binding so long as the employee is free to join another union. So you don't necessarily belong to this particular union. So if you belong to another union, you cannot be fired. So in that sense, this union shop agreement is not forcing you to join this particular union, but it does have a practical effect of deterring you from joining another union. So this is an interesting aspect of our labor unions. And thirdly, sometimes there are multiple unions. So even though there is a union shop agreement, you can't get rid of other unions. And typically, there are two unions. One is majority union, which is friendly and understanding, versus minority union, which is critical of this majority union and oppose everything the employer says. So the employer naturally tend to prefer the majority union and wants to favor this. But our law prohibits discrimination among the unions. So the employee must be neutral. This is a little bit tricky regarding the collective bargaining. So collective bargaining is dealing with the union, and different union makes different claims and takes different positions. So one union says this way, and the other union says that way. So how can we deal with them? And we had complicated cases, and I don't have time to explain all this. But the Supreme Court, we have two Supreme Court cases, and as a general rule, the Supreme Court says that the employer may act rationally and purposefully according to the size and strength of each union, meaning that it is natural and permissible to give priority for the employer to give priority to agreeing with the majority union. However, in both cases, the employer was held to be responsible for illegal discrimination between these unions. So it is very sensitive and tricky to deal with all these unions. So sometimes the employer is have difficulty dealing with these multiple unions. One example being the Nissan Motor Company. It had a very militant minority union and several Supreme Court cases accusing the employer of discrimination. And then I moved to page 4, or another type of Japanese union. So enterprise-based union is the mainstream of Japanese labor unions. But we have a different type of labor union called general union, or recently community unions. So this is open to everyone working in the area. So this is something to help those workers who works for a company who doesn't have a labor union. So especially in small companies, it doesn't make sense to form a labor union among all these workers themselves. So many times there are no union. But if such an employee of such a company wants help of the union, he or she can go to this community union and join this union. And regarding this employees' working conditions, the union is the representative, and the employer must bargain in good faith. And this can happen even after the event. So what is called kakekomi uttai in Japanese. So kakekomi, run to union for help after the fact. So you are fired and you don't belong to a union. And suddenly you feel that solidarity is needed. So you run for a union, join that union, and that union demands collective bargaining with the employer, saying that the discrimination is no good, so he or she should be reinstated. So the employer doesn't have to yield to these demands, but it must bargain in good faith to persuade the union this is necessary or justified. So this is also a different type of mandatory bargaining with the minority union. Finally, in conclusion, the Japanese system is much easier for union to engage in collective bargaining. Simply make a union and demand collective bargaining. However, that bargaining may not be very effective, especially if the union is small in number. And also a difficult problem may arise when the employer bargains with multiple unions, problem discrimination. By contrast, the US law streamlines the bargaining process by deciding in advance which union, if any, monopolizes it. But it seems that conducting fair elections and determining the results can be a challenging task for all the parties involved and also all the society in general. It is my impression. So, and I have questions to ask you to Professor Hyde, but I will reserve it for later discussion. So please, Professor Hyde.
Well, thank you. I look forward to those questions. Thank you, Professor Nakakubo. Everything I know about Japanese labor law, I know from Professor Nakakubo and one of his colleagues at Hitotsubashi. So in the United States, there's actually quite a long tradition of worker organizations that do not represent a majority in any particular workforce, but are active, petition for employees, have community ties. It's a tradition that's attracted more academic interest than numerical strength. There are interesting models, and I'll discuss some of the most important ones, but none of them has really caught on. And I guess you'd have to predict that none is likely to, although, as always, we could be on the brink of a breakthrough here. The possible breakthrough is emergence of some worker organization in high tech companies in California, like Google, for example, where there's been a lot of worker unrest recently and some formation of some supportive organizations. The Alphabet Workers Union, which enrolls employees at Alphabet, Google's parent company. Google management has done their best to destroy a certain cooperative workplace culture that was very important to the employees in that organization, and they're turning to an organizational form. Similar activities going on in other tech companies. It is possible that these small non-majority unions will grow, but unlikely. They will probably continue to enroll a percentage of the workforce, but not a majority. There's a Cummins engineering plant in North Carolina where for 40 years, a non-majority union has actively represented its members in dealing with management. This group, which at some point in the history became affiliated with the UE, the United Electrical Workers, has never had a majority, has never petitioned for a labor board election. But it has strong community ties, particularly among African-American employees. They describe their method as representation by petition. They're big on getting petitions from their members if there's something they don't like what management's doing. Management is under no statutory obligation to bargain with them, but it's an established organization that's seen as the voice of many workers at this particular Cummins plant. And management will cooperate with them, will talk to this union about if one of their members is disciplined or discharged, other issues of this kind. Another similar, I guess, kind of organizations attracted a lot of attention in recent years are what's sometimes called non-union unions. The restaurant worker group in New York. There are actually quite a lot of these. I recently saw the attendance list at a annual conference by the New York City Department of Consumer and Worker Protection. It's interesting that in New York City, those have been combined into one city agency. And that city agency has very good ties with advocacy organizations, both for consumers and for workers. There must have been 30 organizations at this luncheon that were worker organizations, not unions. Most of them received some support from unions, and they represent their members in various industries. So just getting the annual report of the New York City Department and looking at the invitees will give you a sense of some of the activity along these lines. And these groups have some legal advantages over traditional unions. They may have more picketing rights if they want to picket and have a demonstration. They won't. Their union picketing is very heavily regulated in the United States, much too complex for discussion in this format. Many of us thought that this picketing regulation was of dubious. Many of us always thought that regulating the content of union pickets was of dubious constitutionality. Those of us who thought that way were redoubled after the Citizens United case, which blithely observed that as a general matter, corporations and unions have the same First Amendment rights as human beings. That was a lie. It wasn't true then. It was never true. It's not true now, and there's been no discernible constitutional attack on the heavy content regulation of union pickets. But if you're not a union, then you can't commit an unfair labor practice. Only unions can commit unfair labor practices. Other organizations that can't commit unfair labor practices. Some of these non-majority groups can be more nimble. They can be responsive to members. So they have a number of strategic advantages. Why have they not reproduced? I think that the most important factor, mentioned also by Professor Nakakubo in the Japanese context, is the weakness of projecting power. I do not think that the legal factors are the most important, but I could be wrong and you could disagree with me on this. A non-majority union in the United States legal context has all the rights and privileges of a majority union for practical purposes, with but one exception. A non-majority union cannot go to our labor board and get an order ordering the employer to bargain with it. Bargaining orders under the National Labor Relations Act are restricted to unions that have won a majority, demonstrated a majority among employees. Doesn't have to be an election, could be cards or other ways of demonstrating a majority. But an employer who's committed no unfair labor practices has the right to insist on an election. And if it wants bargaining rights, it has to win that election. However, a non-majority union has many other legal rights and privileges, most of the legal rights and privileges of a majority union. It is engaged in protected concerted activity under our labor laws. The employer may not retaliate against it. Just because it doesn't have a majority doesn't mean the employer can fire its members or discipline its members. We also have a non-discrimination obligation of the kind described by Professor Nakakubo. If there is a majority union in the plant, the employer must treat it as the exclusive representative. But if there is no majority in a particular plant, then there's no exclusive representative, and the employer may not discriminate against other groups. If the employer has a favored employee group, this is the Philadelphia Electric case, a long-standing worker representative that never demonstrated a majority, and they have a blackboard and an office, and their steward has time off for handling grievances, the employer has to extend the same privileges to the Black Employees Caucus, challenging that group. So similar litigation involving Northeastern University, where there were competing worker organizations. If none of them has a majority, the employer can't discriminate among them. And I'm not even sure we have the cop-out for reasonable and practical. I think it's a stronger non-discrimination obligation in practice, but the cases don't come up often enough to make generalizations. So a union representing less than a majority can appeal to the public. It can conclude binding agreements with employers that cover only its own members. Those agreements would be enforceable like any other collective bargaining agreement through the United States system. They can include arbitration and the like. So, and the one thing the non-majority union can't get is a bargaining order. And honestly, in my opinion, it's not such a big deal. If you know about the duty to bargain in American labor law, it's pretty small potatoes. The employer satisfies the duty to bargain. This is the employer who has a duty to bargain, has a majority, is facing a majority union. That union is the exclusive representative. The employer must sit down and bargain with that union. The employer does not have to reach an agreement. The employer can come to the table basically and give away nothing. The employer is under no obligation to share any meaningful information. And the employer normally satisfies you to bargain by meeting with the union and bargaining to impasse, a somewhat mysterious term, but not that difficult to satisfy. So, although some would disagree with me, I don't think it's the legal disabilities of non-majority unions that have held them back. It's more a cultural matter, more a matter of tradition, an inability to find the right scale. The largest scale experiment with non-majority representation I know, can think of recently, was something of a failure, and it occurred at the Volkswagen factory in Chattanooga, where the United Auto Workers narrowly lost a representation election in 2014. They fully expected to win it. Management at that time did not oppose the union. There was a team of German managers. Actually, the origin is said to be that the German Volkswagen managers wanted to set up a works council, familiar to them. It's the normal way a German factory is organized. And they were advised by lawyers that it would be a potential unfair labor practice in the American system to set up a works council without a union representation. I'm not sure about that, but that's what they concluded. So the UAW petitioned to represent the Volkswagen workers in Chattanooga. Management at that time didn't oppose them. Some supervisors did, top management did not. It was Tennessee politicians who just went on the airwaves with constant propaganda against the auto workers, and they did lose the election in 2014 narrowly. So they announced bravely at that time that they considered themselves the representative of the almost half the workforce that had voted for them, and attempted to project power and institutionalize themselves for the next election, but it was not successful. And then when the UAW then petitioned, I think it was 2019, for an NLRB election, that one they lost rather decisively. So the idea that a non-majority union could have a presence in a plant, not actually bargaining rights, but be there for the employees, be visible, and this would become the basis for becoming a majority union. I don't have a good example. I don't have a good example of that. Why is American law so rigid on the exclusive representation majority principle? It's not an accident. It wasn't a drafting error. One of the leading employer anti-union device in the 1920s had been the creation of company unions. The earliest draft of what became the National Labor Relations Act had one unfair labor practice for the employer to create and give support to a company union. That was what legitimate American labor unions were most concerned with in the 20s. Then they broadened their horizons. Employers got more imaginative, and unions had stronger demands from the government. So it was unions that very much feared that in a workplace of competing organizations, the employer would create favorable organizations. In fact, that happened to Volkswagen also. Just after the UAW announced that they, despite their loss, they considered themselves a representative of their members, a rival organization appeared that seemed to be well, I don't like the phrase company union either, but that's the one that comes to mind anyway. But both organizations then disappeared. The United States limiting of bargaining rights to majority unions is not an overlooked feature of American labor law. It's been criticized for decades, particularly by Professor Clyde Summers, who taught both of us. So it's not surprising we see eye to eye on almost everything. There's been a tremendous interest in community unionism, beginning with Professor Charles Heckscher's work in the 70s, a theme that's been picked up by Professor Estlund, who's in the room with us, and Kathy Stone and others who've written in favor of my Rutgers colleague Jim Pope, others who've written about the importance of community unions that are not limited to the workplace but have good ties with community organizations. The recipe for labor rejuvenation that was common when I was in college, and that's a long time ago, had to do with labor union links with environmental organizations and community organizations and so forth. And who's to say that this may not happen in the future? But and that one of these perhaps one turning point, one significant victory by the Alphabet Workers Union at Google could inspire a cascade, just like these Starbucks union elections seem to be perpetuating themselves. But right now, I would just conclude by saying there are templates, there are models, there are patterns of non-majority unionism of the community type or the caucus type or limited to particular ethnicities. They have achievements, they have a history, they have more legal rights and privilege than people think, but they've never institutionalized themselves as a dominant or really even significant part of American labor.
Okay, well, thank you for the succinct overviews of both the Japan and U.S. Labor law and unionization systems. One quick question. This sounds like a significant difference, whether you have a rule requiring majority unions or you don't. As a practical matter, how important do you think it is? And also looking internationally, which rule is the majority rule, which is the outlier between Japan and the US, if I may ask?
Mandating bargaining is not universal. In European countries, actually, there are collective bargaining, and so they are mostly concerned about the collective bargaining agreements, which are concluded after this bargaining. But in the United States, employers were so much opposing to bargaining itself, so the law intervened and created this duty to bargain. And it was important to us too, but without the exclusive representation. So this is an interesting aspect, I think.
So far as I know, the rule of exclusive representation by the majority union is uniquely American, and Canadian. I was getting that. Our friends know I'm very sensitive to Canadians who borrowed it from south of the border, as they borrowed much of their labor law. Employers elsewhere in the world just may have to deal with competing organizations. Bargaining may be different. Bargaining may take place under government supervision through extension processes or various kinds of government creation of bargaining apparatuses. There may be works councils and division between what's the works council's responsibility and what's the labor union's responsibility. It's been common in various European countries at various times to have a communist union, a socialist union, a Catholic union, a Protestant union. No one ever thought it was necessary to have a majority. If they work together, it can be a very effective way of representing it. If the employer divides them and plays off one against the other, well, the employer can win that game. They can win it on this side of the Atlantic, and they can win it other places too. So as I said, I just don't think the absence of legal bargaining rights is the real impediment to the growth of non-majority unions. They can do plenty, and their potential remains largely unexplored.
Well, you mentioned the Volkswagen case. And so for those of us who are interested in Japan and Asia, we notice the trend, or at least the perception, that Japanese and other Asian companies, when they come to the US, they seem to flock to areas that historically are not favorable to unions, even though they're quite accustomed to dealing with unions in their own country. Do you have a particular explanation for this? It seems and maybe you want to just save costs, or they're worried that the union won't be as sympathetic to the company goals.
Japanese employers are fearful of UAW or these American unions. They are not our enterprise-based unions, so they are not very concerned about particular employers' profitability or viability. So that's why they avoid northern states. That is my impression.
I think that's true, particularly in automobile. Right. If those Japanese automakers were faced with Japanese unions that just happen to have Americans, their attitude might be different. But they definitely associate the decline of the Detroit automakers with what they see as unreasonable bargaining demands by the UAW. I think that's an oversimplification at best, but my understanding is that's exactly how Japanese automakers.
Well, please, Chris Westland, please. I was
Sorry, I'm
gonna
really
ask-
sorry for being late. I was in the store. fortunately corral my friend here.
There wasn't enough room.
I was thinking what a terrible room it was, but anyway, and I apologize if I have to run out early because I'm teaching a seminar on labor and the Constitution, and the session today is on the right to strike. And I'm under. But I'm wondering, Alan, if you're not soft pedaling the weaknesses of a not majority vote for the union. They are, what they can do besides demand legal, obligation to bargain is solve the so-called free rider problem by bargaining for the entire unit to, you have to pay your union dues. That unions in the US seem to feel that that is one of the things that makes right to work states very difficult, because in right to work states, you can't do that either. It's the only thing that states are allowed to decide for themselves within a federal labor law regime. But the free rider problem in principle isn't a uniquely American problem, right? So other countries need a way to deal with it. And
So do public employees in America now.
Yes, right. Although, I think in some public employment contexts, the government employer bears some of the burden of the costs that the union otherwise has to bear. And I suspect that's also going on in Japan, that the company union, at least where there's only one of them, a lot of the costs may be borne effectively by the employer. That's one way to mitigate the free rider problem. In Europe, with this multiplicity of unions, works councils, which are largely supported by the employer, that's not a cost. That's one solution. That's how workplace issues are dealt with. And bargaining takes place at the sectoral level, which is a much more efficient way to do bargaining, right? So I think in the US context, given I think zero prospect of real sectoral bargaining. And given, the company union prohibitions that we have, I think that the problem that minority unions face, although, it should allow them to do a lot more than they are doing, and I think you're absolutely right about that, it is a pretty serious impediment to their doing what we would consider to be real collective bargaining.
If I may, that was the precise question that I wanted to ask Professor Nakakubo, is how union shops work in a workplace without a majority union. Union shops are also a feature of American labor law, for those who don't know, but limited, as Professor Estlin correctly says, to the majority exclusive representative.
Union shops in the United States is unique in that it is catered to financial core. So all you have to do is pay union dues. And that is necessary because it is exclusive representative. So even non-union members are covered by the collective bargaining and this agreement. So you have to pay for this service. In Japan, we don't have such a system. So each union represents its own union members. And of course, each union members have to pay dues for the service of this your own union. So if you don't like this service, you can simply quit this union. And if there is a union shop agreement, you can't be a non-union, but you can belong to another union and pay dues to that union. So we don't have such a free rider problem.
Although, as you say, Japanese, I wouldn't have said this, but since you said it, Japanese people like to follow along with what other people do, and that may be one of the key answers to the free rider problem.
So under Japanese law, in a workplace with several unions functioning, none with a majority, who concludes the union shop agreement? Or is that just a legal default?
Usually, when there is a majority union, that majority union concludes a union shop agreement. So it is rare for an employer to conclude such an agreement with the minority.
Okay, but if a given worker who prefers representation by the minority union may elect to pay dues to that union, and then that worker satisfied their obligations.
Yes.
It's nice.
Well, I was reminded of a question, take a step back for we non-specialists. I think we have heard that in much of Europe or Germany, there is sexual bargaining, and we don't have that in the US. But could we talk a little bit more about the relationship between national looking unions and actual specific agreements with individual employers and individual plants? For example, in Japan, as Professor Nakakubo mentioned, every year the annual spring wage labor offensive Shunto is in all the papers. The prime minister, since Prime Minister Abe is always talking about raising wages, business organizations, the largest one being Keidanren, seems to be encouraging their corporate members to raise wages. So there is kind of lots of publicity or public speaking at the national level. To what extent, if any, does that affect what actually happens in individual companies or plants, either in Japan or elsewhere? I don't think that some of us who aren't that knowledgeable of labor law have a good sense of the interaction.
So for Japanese employers, if the government and everybody says we should raise the salary, it is becomes easier because the atmosphere is very important. So the government wants to make the employers to make it easier to raise salaries. This is necessary because companies are accumulating money for a rainy day. So, and this is not good for the good economic development. So the employers know this, but they have to act in a positive way. So that is the encouragement from the government and the public opinion.
Well, I must comment that until very recently, all that encouragement does not seem to have been very successful.
Right.
And to what extent, I think I've read that maybe it was Toyota that now for the third year in a row, the company is accepting all of the union demands, which doesn't amount to a huge raise apparently. So
Toyota unions are very modest.
Modest, okay. So is it true then that the unions also place a far greater emphasis on issues like job security than wages? Is that part of what's going on? I mean, there's lots of talk and lots of
probably yes.
Not so much action from what I can see.
So because we had such a very bad years of economic slump, people are more concerned about job security. But now, because the prices are increasing so high, and now people are thinking that we should have much more increase. So perhaps the tide has changed.
Okay, so you need some inflation.
I would answer your question, but Eskelin knows much more about this than I do. The importance of the Shinto can be demonstrated by its absence in China. And I'm told that in China, there isn't a recognized way of raising wages, even in situations where Chinese employers are facing labor shortages and labor unrest. The government doesn't coordinate these things. They do not have independent labor unions, even friendly unions on the Japanese style. They're not. The unions are arms of the party, and that Chinese employers feel the absence of a mechanism for raising wages.
Well, they can raise at the provincial level, they can raise the minimum wage, and the percentage of workers who are paid at the minimum wage is very high in factory work. So that did happen quite a lot. Wages did rise a lot over the last couple of decades. But you're right, I think it isn't maybe centrally controlled in the same way. It's such a vast country, the mountains high, etc. So yeah, that has been the main mechanism for raising wages.
Another issue that has come up in the Japanese context quite a bit recently is a very new emphasis on labor mobility, as perceived as one kind of partial solution or cure to stagnant economic growth. So do unions play any role in that? I mean, I think the general trend has been that at least large companies, compared to 10 or 20 years ago, have more lateral hires. It's not necessarily everyone just out of college. The company I'm most familiar with, I was associated with as an outside director, they probably take a third of their employees now from outside, not coming up through the college ranks. So that's slowly changing, but probably that system is still in place. When the government talks about labor mobility, what sort of measures do you think they have in mind to try to encourage labor mobility, and what do unions think about?
I don't think it is related to labor unions, but the practices of Japanese companies. And I think many companies are hiring from mid-career hiring.
Yes.
I'm teaching at the night school, and they work during the day and they come to study law at night. And most of them are moved to different companies. So I think employment, lifetime employment is very popular, but the reality, many people are moving between these employers, and for good reason. And Japanese government is now trying to emphasize or accelerate this trend, but it seems to me the trend is already there.
And what would the government try to do to accelerate it? Encourage ongoing professional education like you were engaged in?
Yes. Also, increase the overall productivity, so not limited to one particular company, but she may have a better position for a better professional prosperity. So,
Yes.
Are they talking about cutting back on the level of job security? Because, mobility goes both ways, and if it's really, really, really hard to fire anybody,
yes.
you're not going to have as much room to hire new people. And people who might want to quit and move they might be inhibited from doing that.
So some people are talking about reducing the scrutiny of Japanese courts regarding termination. The courts are sometimes very rigid. But it is very difficult to change the attitude of the individual judges. And also there are many ways other than dismissal to make people leave. So Japanese companies are very good at doing this.
So one example would be, in the case that I'm familiar with, repeated voluntary buyouts, focused on people in their mid 40s to late 50s,
Or even older.
Yeah.
well, and that would
Inside job.
yes, that would encourage younger managers to assume more responsibility. That would result in a greater percentage of female managers in the workforce than before. And also, I think underlying all this is the ongoing need for specialization. If you want IT specialists for part of your digital transformation, which in Japanese is DX, doesn't sound Japanese, but it's hard to train those people in-house. I think that's one of the big underlying trends supporting what Mr. Nakakubo was mentioning. Catherine, is anyone?
Yeah, I have a few questions from the online audience. I'll start with a couple coming from Professor Alvarez, our faculty director. One is sort of a simple fact question for Professor Hyde. You spoke of non-union unions as being more common than we may be aware. And you said the unionization rate, percentage of workers represented by unions, is 10%, the lowest in recent memory. What would the unionization rate be if you included these non-union unions?
Difference.
Uh-huh.
Unionization rate went up during the pandemic because so many jobs were eliminated. I mean, the idea that the unions are having a resurgence is largely anecdotal and comes from one union victory at Amazon, which is not going to amount to anything because they haven't been able to replicate it anywhere else because Amazon is very big and powerful and this union is not. And that would be a major setback. The union victories in Starbucks, which do seem to be replicating themselves. So we'll see what happens there. Also very difficult for people, local organizations, with local grievances to bargain with an organization as big as Starbucks. But that, and things like the Alphabet Workers Union.
Okay. So if we broaden our understanding of unionization or unions or representation to include these other things, it doesn't really change the picture in the United States.
No, they're interesting things to think about. Labor intellectuals have been writing about them for a long time, but numerically it's not. It's not a large group.
So then he, Professor Alvarez asked, well, which approach, the Japanese approach of allowing, a multitude of minority unions, or the U.S. insistence on an election, which approach is more consistent with ILO conventions 87 and 98, which are the relevant conventions? And unfortunately, he hasn't provided me with text of those conventions.
Oh, well, I have them. No, I don't.
I'd recite them. We don't have to.
My memory is that the ILO, in fact, has been critical of the American practice of exclusive representation. They feel it's an impediment to what in ILO parlance is known as freedom of association.
Another question, which also lacks a certain context, is asking about the Postal Workers Union, which I assume is meant the U.S. Postal Workers Union, since it's not specified which country. And how, no, but the question is simply, is this similar to how the Postal Workers Union operates? But I'm not sure what was being said at the moment when this question was typed. So, but does the postal, let's just apply this broadly, does the Postal Workers Union, it must have passed a majority election, it must have been certified in the process you were talking about. What kind of representation have they been able to achieve for their workers?
Assuming that we're talking about the US.
Well, I think we must be, but.
Well, if we are, the Postal Service is governed by the National Labor Relations Act. I assume the reference is to kind of craft organization. There are a number of unions that bargain with the Postal Service. The letter carriers have a union. The people in offices and people in mail sorting facilities have a union. So it's kind of an older craft organization. But I believe that all those organizations are majority unions that have won union elections and can and sometimes do go to the labor board for complaints about management.
Majority within a narrower bargaining.
Right.
So
That's another.
you seem to have other unions in Japan that separate out to subsets of the. So we have multiple unions in lots of places, but they are all majority within a certain occupational group.
Right.
Which is very different.
There's no union for Japanese postal workers.
There are many.
I thought this question was addressed
To Japan,
to Japan.
maybe.
Yes, most of the service was made by the government in the past, but it was advertised, and there is a dominant union, but there are several minority unions, and they compete with each other, and the employer is having a hard time dealing with them.
Very large employer.
Yes.
So has there been any kind of a survey or study of worker attitudes towards these two approaches? I mean, do workers in Japan like having this selective capacity and freedom of association?
People take it for granted that everybody is free to join the union of his or her choice. So we can't imagine. But I must say that we do have majority a majority union have such special some special rights under the Labor Standards Act. So when there's overtime work, the employer must have an agreement with the majority union. But that doesn't hinder the minority unions from engaging in collective bargaining. So this is very different. But majority union has some special additional functions.
So practical question is,
Surveys of American workers typically show that they really want unions, but they don't want the unions that we have now. This is a paradox that no one has managed to square.
So the obvious question is, what sort of unions do they want?
right,
Wow, well, that's
Well, I mean, the best survey information on that suggests they want organizations that are able to cooperate with the employer in ways that are illegal under American law. So many paradoxes all around.
So you antitrust violations?
No, violation of the labor laws against company unions. Cooperation is highly suspect.
So we still have a lot more to learn from Japan.
right. So a practical question, if you have multiple unions in your Japanese workforce and the company is negotiating with each of them separately and is not able to favor one over the other, must be neutral. Does that mean that is there a kind of like a most favored union rule where if Union A has achieved something for their members, no weekend work, you're not required to answer emails on the weekend. But Union B didn't negotiate for that. Does the company have to extend that win to Union B's members or not?
It is not necessary. So the achievement of that particular union, so the union can keep it. But sometimes the rules must be universal, applicable to all the workers. So in that case,
You mean in a practical sense?
Yes,
Or
yes.
not legal, it's not legally obligated to extend it, but just practical.
Right. So some conditions can vary depending on the union, but other we have to work together and so what is the starting time, and so in that case the employer unify the conditions. So by making an agreement with the majority union, and that conditions becomes applicable to all the employees through the work rules. So we have the system of work rules, so that can't violate the collective bargaining agreement. But that collective bargaining agreement is incorporated in the rules of the employers, and this applies to all the employees.
Well, thank you. I'm afraid we've gone over our time by several minutes already. So I would like to thank our two speakers, Professor Nakakubo and Professor Hyde, for a very interesting discussion, and thank all of you who joined us today. We hope to see you again 2 weeks from today.